This is Michael Popak. Look at the hour. Look at the time. It's Legal AF After Dark. And let's now talk about this, what's going to be a failed attempt by Donald Trump to take his case, where he's already been convicted of 34 felony counts in New York, away from Judge Merchan, right at the moment, the 11th hour before he is sentenced for his criminal conduct, and try to drag it across the street to Judge Hellerstein. It's a tired old playbook, to paraphrase Vice President Kamala Harris, and this one's going to be about as successful as the last time he tried to do exactly this back last summer. It's going to fail. Plus, he's got it directly upside down as to his failure to comply with the rules and procedure in order to try to even take your case to federal court. As a federal court practitioner, right here in this kind of court, in this kind of courthouse, I break it down for you, along with my colleague, Ben Meiselas on Legal AF. Take a listen.
Michael Popak, it has been a very busy legal week. I mean, earlier in the week, we learned that Donald Trump was trying to remove the Manhattan District Attorney criminal case to federal court. Pretty curious, because people are saying, remove it to federal court. What? Didn't he try that already? Wasn't he convicted of 34 separate felony counts? Isn't his sentencing scheduled for September 18th? Yes, all of that is true. So what is Donald Trump trying to do? He's trying to throw a Hail Mary and basically trying to say, look, the Supreme Court made this absolute immunity ruling, and therefore that addresses federal issues that just arose. This is Trump's argument. So as a result, we have to take this state court prosecution where I was convicted on 34 felony counts for falsifying business records. And because of the Supreme Court, federal Supreme Court, we have to then bring it into the federal system. Just a reminder, there's a federal system. There is a state system. Where there are state crimes, it goes in state court. Where there are federal crimes or a federal statute, it goes in federal court. There's something in the Constitution called the Supremacy Clause, where federal is supreme to state if there is a conflict. So if there's a federal law that covers the same territory or supersedes the state law, there are circumstances where, under the rules, a criminal case could be removed to federal court. Now, you'll recall when the indictment was first brought against Donald Trump a long time, fairly long time ago, relatively long time ago, by the Manhattan District Attorney. When that indictment dropped, Donald Trump tried to bring it to federal court before it got assigned to Judge Hellerstein. There was an evidentiary kind of hearing that was held. Trump lost. Judge Hellerstein also noted that Donald Trump waived a lot of kind of key issues, and Judge Hellerstein sent it back to state court where the criminal proceedings took place, and Donald Trump was convicted. So based on where the case is procedurally, the case is over in the sense, right? Other than sentencing, so it's not totally over, but there was a conviction. We're at sentencing. So because of that, for you to try to move it to federal court, because of the fact that all of these proceedings took place, there is very specific law at the federal level that says you need to follow certain rules. You have to either get permission from the court. In other words, you have to get what's called leave, or you have to get consent from the district attorney. You have to then first file a motion to request leave of the court to remove it to federal court. And you need to, once you remove it, meaning literally when I say remove it, I mean you make a filing in the federal court transferring the whole file from state to federal, you have to include a certificate that either says the district attorney agreed or the court agreed. And if that doesn't exist, it gets rejected. And so because the certificate was not included, the way Judge Hellerstein, the federal judge, rejected the removal is kind of the way a judge would reject a filing in federal court if you just filed the wrong form. So I can tell you, as previously practicing law, and Michael Popak currently practices law, sometimes you'll make a mistake with the filing. You'll file form A088 instead of A087. and you screw up. It's a pretty embarrassing thing when that happens, but you deal with it. But it happens from time to time. You don't want it to happen a lot because it's not a good look if that happens. But it'll be rejected by like the court clerk, and it'll say defective filing. You filed the wrong form. So the way Judge Hellerstein dealt with this was that you filed no certificate, therefore I'm rejecting it. Please refile with certificate, as though you missed a document. Now, Judge Hellerstein knows that document doesn't exist. So he did it in a way also that was kind of a way to humiliate Trump and Trump's lawyers by saying, okay, just file the document and I'll take a look at this, knowing that that doesn't exist. Then Judge Hellerstein doesn't even have to even look at it or address it. Now, do I think that Donald Trump's lawyers are going to refile? I do, but they're going to have to either get consent of the court, which can be rejected at this stage, or consent of the DA. But all that happened very, very quickly. Popok, let me turn it over to you.
Yeah. Let me tell you why it's so important. Because there is a unique quality to a party filing a notice of removal. It is a special power that is so powerful that it has to be handled appropriately, wisely, and there has to be a gatekeeping function for the federal judge to make sure. The power of a removal, a notice of removal, is that if it's done timely, and this one was not done timely, I'm going to talk about that next in reference to the rule 1455 of the statutes, which deals with removal. If it's done timely, a removal notice in and of itself divests jurisdiction and takes the power away from the state court judge at the moment the notice of removal is filed, unless and until the federal judge, having seen the notice of removal, either with a hearing or on the papers or on reviewing the papers him or herself, decides that the notice of removal is invalid or rejects it and then remands it back. Even for a nanosecond, the Judge Merchan, who's waiting patiently to both issue a ruling about immunity and how immunity, if at all, applies to any aspect, evidentiary or any aspect of the 34 felony count conviction of Donald Trump. Operative word is trial happened, arraignment happened, trial happened, conviction happened. So we're post-conviction pre-sentencing period. Pretty rare air to be breathing to ask for removal to federal court at this late stage. It's really untimely unless you ask permission first. Pretty please permission from the federal judge, Judge Hellerstein, about removal, which they didn't do. So the reason this has to be so carefully guarded, it's like a superpower, it's like kryptonite that's locked in a box, is because it divests the state court judge of jurisdiction at the moment the notice, if it's proper and regular, is filed. So here, you don't get that benefit. And because the rule, and we can put it up here in a minute, the rule 1455 says as follows. And you might be saying, well, how do you even address this issue? It says that, first of all, that a defendant, this is under B1, a notice of removal of a criminal prosecution shall mandatory be filed not later than 30 days after the arraignment in the state court or at any time before trial. Well, Trump's effed under that because he got arraigned a long time ago. We on the MeidasTouch Network did a lot of coverage about his arraignment, and he got, forget about the trial starting. The trial started, finished, and he got convicted. So we are beyond timely removal under B1. So then what do you do then, Popok? Does that mean he's out of time? Well, that rule goes on to say, except that for good cause shown, the United States District Court, meaning Judge Hellerstein, may, that means permissive, discretionary, enter an order granting the defendant or defendants leave to file the notice at a later time. So what is Judge Hellerstein / the clerk saying in this entry that we posted and you and Harry covered in one of your hot takes? The clerk / judge is saying you needed to file a motion for leave to file your notice of removal because you're so late and you got to show good cause. And only if I, Judge Hellerstein, grant you permission based on what you tell me is the good cause, and I believe it, I don't even need to hear from the other side. I'll just look at your papers. I may or may not let you file the notice of removal. But because you did it wrong, I am bouncing what you filed. Jurisdiction has not been divested out of Judge Merchan, who still sits over the case. Everything is undisturbed over there. And I may never divest jurisdiction or allow you to divest jurisdiction of the state court judge. Let me look, and I'll let you know if I'm going to let you file a notice of removal. And that is the gatekeeping that we just watched so effectively and quickly happen. I did a hot take in the morning about the filing, and by like the afternoon, Emile Bove got a dunce cap put on him by the clerk/judge about it. And what they're doing is not just saying, as you said, it happens. I've had it happen recently in one of my cases in federal court. My staff just can't figure out how to file something related to a sealed document, and it kept getting kicked until they figured out the right button to push. That's different. Here, it's you need to ask my permission. And I'm not even going to allow you to argue with that for a nanosecond. Judge Merchan in the state court doesn't have jurisdiction over this case. Let me take a look at your paper. So they're going to refile this. Even though the rule doesn't say get the consent of the DA, I guess what the judge is saying is, I guess I'll give you the good cause and let you file if you can somehow convince Alvin Bragg that at the post-conviction pre-sentencing stage, this thing should be dragged over to federal court so that you can take some sort of appeal through this is what they're trying to do. They're trying to jump the tracks and get over to the federal system so they can have an easy path and line of sight to the federal courts and federal courts of appeal, like the Second Circuit Court of Appeal, and then over to the Supreme Court. It's a lot easier than what they needed to do, because everything, and you did it too with Harry, and I did it in my hot take, everything in the papers Emile Bove for Donald Trump filed, everything is just an appellate issue for them to argue once Judge Merchan is given the benefit of the doubt about his immunity decision. The judge has not issued his immunity decision yet. So you can't appeal it, and you can't appeal it to a supra appellate judge in the form of a federal judge sitting in removal. So everything in there is, we don't like the jury instructions. We don't like the way the evidence was presented. We don't like some of the things that may have been immunity that was presented to the jury. We don't like some things that happened at the grand jury. We don't like the judge because he's got a daughter, stupid stuff. And all of that stuff is grounds for appeal if you think you got it to the state court appellate. You and I are spending a lot of time methodically talking about the difference for our audience between state and federal practice, because frankly, you don't learn that unless you go to law school. In America, you don't really learn that at all. So and it's important to one of the takeaways from our patreon.com/legalaf stuff is that people understand our procedure and understand the differences between the state and federal system and why they exist and how they interplay. And that's what we're watching here, the intersection of those two systems. So go take your state appeal. That's fine. But you got to wait till the 16th when the judge rules probably against you. And then when the sentence happens, you can go argue about the sentence too. And the judge, Merchan, the reality is he'll stay his case. We are pretty confident while you appeal. So go do that and get your brief ready now, because the brief that Merchan is you should have that typed up already with you just probably need a half a day to customize it once you see the actual order. And that should all be done in the state court system at the First Department Appellate Division, which is the place in Manhattan you go for your first level appeal. And if you don't like the answer to that, you're on the losing end of that, Trump, then go to the Court of Appeals, the highest court in New York. And that's it. That's sort of the end of the road. But this transparent attempt to try to get Merchan off the case even for a minute before the prosecution, hope that Hellerstein holds a hearing. Here's my prediction. Hellerstein doesn't hold a hearing at all. Emile Bove tries to refashion what he just filed as a motion for leave to file a notice of removal out of time, untimely. The judge looks at it and within a very short time, no more hearings, no more evidentiary hearings like he did back in May, June, and July of last year. Done, denied. You don't get to file your notice of removal. You sit tight and sit still in state court. That's what I think is going to happen. And it's going to go really quickly after Labor Day. I think you and I are going to be reporting during next week about Hellerstein saying, see ya, bye. You're not doing that. And Judge Merchan, have a nice day in your immunity decision and on your sentencing. Welcome back. That's a show that we created 4.5 years ago, anticipating presciently these trying times and to try to make sense of them. We call it Legal AF for a reason. Now you know why. Join us on Wednesdays and Saturdays at 8 p.m. Eastern Time. There's a little plug. See the logo? Where you'll get the full curated podcast. It's about an hour long. We do 3 or 4 stories at the intersection of law and politics. We don't blow smoke or sunshine. We're not censored. We're completely independent. And the way you can help us is to join our audience. Free subscribe to the MeidasTouch Network. Listen to our show. Plug in Legal AF wherever you get your podcast from. If you know about Legal AF, you're already part of the audience, part of the 3 million strong of the Meidas Mighty. We appreciate you beyond our words. I can't even describe to you how happy we are. When I joined this network or this band of brothers, I think I was employee badge number 4. And there were 54 people that were watching our episodes. And now with your help, we're one of the leading podcasts at the intersection of law and politics. So send this clip off to people in your life and friends and family. See if I can get rid of these bugs here flying around my room. And send it off to friends and family and people in your life and ask them to join. We're growing organically. That's how we got to 3 million to begin with. And if you don't know what I'm talking about or what MeidasTouch is or Legal AF or Michael Popak, this is our invitation for you to join us Wednesday, Saturdays, 8 p.m. Eastern Time, right here on this YouTube channel, where we curate the top 3 or 4 stories at the intersection of law and politics. And then you can pick us up on all audio podcast platforms. There we are again. There's our album cover. So until our next hot take, until our next Legal AF, this is Michael Popak reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.